You, Mr. Hibner, and thank you, Ms. Bowders and Mr. Shackelford, for joining Judge Stafford, Judge Armstrong, and I in this oral argument today, which we are live streaming for the public at large to view. And our argument is being recorded, and it will be posted on the court website for future reference by you and the public at large. We will conduct today's argument in the same fashion as if all of us were together in the courtroom. Each of you has 15 minutes, and Mr. Shackelford has saved some of that time for his rebuttal. Before we begin, let me confirm that the widow is not participating in the argument. Is that correct?
That's my understanding, Your Honor.
Okay, very good. So it'll just be the two of you. Very good. Mr. Hibner, please call the case.
Bradi M. Baker-Brunkhorst versus Geoffrey B. Brunkhorst.
Mr. Shackelford, you have the floor.
Thank you, Your Honor. My name is Hank Shackelford, and I represent the appellant, the estate of Geoffrey B. Brunkhorst, who's deceased, and of course, his children, the three children of Mr. Brunkhorst. I want to reserve 5 minutes of my time for rebuttal, as I have previously asked. You know, Your Honor, this case boils down to some simple questions. The first question, the most important question, is that do the attorneys for an ex-wife have the right to file a lien against real property awarded to the ex-husband via marital settlement agreement and divorce decree contracts when the ex-wife was responsible for paying her own legal fees and the ex-husband was not? That's what's happened in this case. The second question I would ask the court to consider is the Roberts case, which I've cited in my briefs, which stands for the proposition that the marital dissolution agreement is a contract and entitled to full enforcement of both sides, and also stands for the proposition that title to real property awarded to a particular party vests in that party as of the date of the divorce decree without the necessity of further action of either party. Is Roberts still good law in the state of Tennessee? I think it is, and I think it should be controlling in this case. Third question is, if so, can an attorney properly file an attorney's charging lien in order to collect their fees against property owned by another when that party was not ordered to pay any of those fees? Palmer case says no. I think Palmer is still good law in the state of Tennessee. Fourth question is, if as the record states, the ex-husband, after being murdered by the ex-wife, dies intestate, does the property awarded to him, the real property in the marital dissolution agreement, vest in him according to Roberts? And if so, does Tennessee Code annotated 31-2-103 control, which says upon the death of a person who dies intestate, that property, real property, immediately vests in his heirs, his children? So if Tennessee Code annotated 31-2-103 is still good law, I assume it is, how can a law firm file a lien against property vested in the children of the ex-husband for attorney fees owed by the woman that murdered their father when the ex-husband had never been ordered to pay such fees? Now, I admit I don't do a lot of domestic relations law, but these questions trouble me, and I hope they trouble you as well. The facts of the case are relatively simple. I don't think they're complicated. I've stated them in my briefs. I'll quickly say that there was a divorce. There was a marital dissolution agreement, a divorce decree entered on the 14th of December, 2018, and it became final 30 days later. 2 pieces of real property were awarded to the ex-husband, and he was ordered to pay the ex-wife $115,000 in periodic payments, which he was paying until he was murdered. She was ordered to quit claim the real property over to him, but she refused and did not do so within 30 days of the final decree. On April 8th, 2019, the ex-wife murdered the ex-husband. Now, on April the 15th, 7 days after he was murdered, approximately 4 months after the marital dissolution agreement was entered, about 3 months after it became final, and this marital dissolution agreement was obviously negotiated by the Appellee's law firm, they filed a notice of attorney's lien and motions that resulted in this lien being filed against any property, and property continued to be at that point in time in the name of both parties, even though Robert says it vested in the husband when the divorce decree was entered. On the 23rd of May, I opened the estate of Mr. Brunkhorst. Both properties had mortgages. They were delinquent. It was a difficult position. I filed motions to have the property properly transferred to the estate. I filed motions to have the lien vacated. Judge granted my motion, one of the motions to have the property put in the name of the estate, but denied the motion to vacate the attorney's lien.
Mr. Shackelford, Mr. Shackelford, if the real property vested immediately upon his death in his children's name, how could you have the property transferred to the estate thereafter?
That may have not been proper. At the time, I thought it was a good idea, but at the time, I'm not sure that I was totally aware of statute 23 that I've just cited.
Okay, but as we speak, the property in question is titled in the estate's name.
The property is gone. It has been foreclosed upon. Okay. It is over with. The only thing that remains, $10,300 is still in escrow.
That's right. I forgot that had occurred. But when the property was foreclosed upon, it was titled in the name of the estate.
It was still titled at that point in time in the name of Mr. Brunkhorst and joint tenancy with the right of survivorship, Brady Brunkhorst.
Okay, well then I'm confused. You said you had the property transferred to the estate, so.
Afterwards, after it was foreclosed upon. There were two properties.
All right, you've really confused me. I'm sorry to say.
There were two properties, Your Honor, and one property was in foreclosure at the time that we were trying to make these arguments, and the foreclosure went through. So transferring the property had no effect because it was foreclosed upon.
But is there another piece of property that's been transferred to the estate?
It was foreclosed upon as well.
Okay.
Your Honor, I guess my first point is pretty obvious. As stated in my brief, I've been unable to find any provision in Tennessee law that allows a wife's attorney to lay claim to property awarded to the husband in a divorce decree for payment of the wife's legal fees when the husband was not ordered to pay the fees. If that's what's happening here. Your Honor, I maintain that the MDA was a contract between the parties and it should be enforced as written, not rewritten at a later time by Judge Atkins, which is my argument of what he attempted to do. I maintain that the Roberts case, cited in my brief, states clearly that the title of the property awarded in the divorce vested in the husband at the time it was entered and became final. So that in that case, there's a famous quote that says, "Is it necessary to convey by deed an interest in property which was awarded by the decree of the court?" And the court says the answer is negative. If title in the property vested in Jeff when the divorce action was entered, how can a court come along later and allow an attorney's lien to be filed against that property for fees owed by the wife to her attorneys when the ex-husband was not ordered to pay some? That's just wrong, Your Honor. If Roberts properly vested the property in Jeff, it's also true that pursuant to TCA 31-2103, the property vested upon his death in his children immediately. But if that's true, 7 days later, why could they file an attorney's lien against that property? I believe it's just wrong. I believe that Palmer.
Mr. Shackelford, let me ask you a question. Was the decedent supposed to pay his spouse, pay the spouse some money as a result of the transfer of the property?
He was ordered to pay $115,000 in periodic payments, which he was doing until he was murdered.
And what happens to that, assuming the property vests immediately in your client upon the entry of the MDA and divorce decree?
My client, if he was alive, would still be liable to pay that money.
Well, does the debt extinguish upon his death?
No, Your Honor, I think it could be a claim against the estate, but no claim has been made against the estate for that. I think it's a claim that the ex-wife could make, not the attorneys for the ex-wife, who, by the way, are now no longer representing the ex-wife.
Well, I'm trying to understand the logic here of your position, and that apparently the logic is the wife owns an interest in property, but once the divorce is granted and once the MDA is approved and the divorce is granted, your position is the property immediately vests in your client. Does the wife have any possessory interest in that real estate, because she's going from something in which she had security to essentially an unsecured debt, where the best she can do under your analysis is file a claim in the estate?
Yeah, there was no provisions for a secured interest in the property in the marital dissolution agreement. And since the parties agreed to that, and there was no such secured interest, she had no secured interest.
All right. Thank you, Mr. Shackelford. We'll hear from you on rebuttal.
Thank you, Your Honor.
Ms. Boris?
Good morning, Your Honors. Thank you for hearing from us this morning. Your Honor, I think that the crux of this whole argument stems from the mistaken idea that BSHR, Butler, Severe, Hinesley, and Reed, is trying to enforce a lien against property that is owned by the husband and as a result, by his estate or his heirs. That is not what is happening here, Your Honor. BSHR has a valid and enforceable attorney lien, which has been upheld by the trial court on 3 separate occasions as valid and enforceable, against assets that are properly owned or owing to Ms. Baker-Brunkhorst, BSHR's former client. The marital dissolution agreement did not divest her of her interest in this real property and vest it in the husband, as was the case in Roberts v. Roberts, cited by Mr. Shackelford. Instead, what happened was the parties came to a global settlement in which wife agreed to execute a quitclaim deed 30 days after the entry of the final decree in exchange for payment for the entirety of the equity in the property. It is that equity that BSHR is trying to collect against. That equity, i.e. the sale proceeds, belong to Ms. Baker-Brunkhorst, BHR's former client. And that is what the lien is trying to collect upon. It has nothing to do with Mr. Brunkhorst's estate or trying to take money from his heirs, Your Honor. Your Honor, Mr. Shackelford cited the case of Roberts v. Roberts. And in that case, the marital dissolution agreement contained the specific divesting and vesting language in which it said that all the right, title, and interest to the property would be divested out of one party and vested in the other. That marital dissolution agreement was then incorporated into the final decree of divorce, by which that property was then divested and vested in the other party by a decree of the court. That is not what happened in this case. There is no such language in the marital dissolution agreement. And even more importantly, Your Honors, there is no such language in the final decree. Instead, the final decree's language follows the language of the marital dissolution agreement that says, wife shall execute a quitclaim deed and she shall receive in exchange payment for the equity in the property. So I agree with Mr. Shackelford that Roberts v. Roberts is good law, and that Roberts v. Roberts stands for the proposition that if property was transferred by a decree of the court, then that is sufficient to transfer title to property. However, that's not what happened here. And I think the most telling evidence of that was, Your Honor, Judge Clement's question, and that is, if the property did vest upon signing this marital dissolution agreement or upon entry of the final decree, then why was it necessary for the estate to file a motion to enforce the marital dissolution agreement in this underlying divorce action in order to sell the property. Now, it's my understanding that one property was foreclosed upon, but the second property was actually sold. And it's those sale proceeds of approximately $10,000 that are being held in the closing attorney's escrow account and has been held since that time. Mr. Shackelford, on behalf of the estate, as personal representative for the estate, could not complete the sale of that property. Why? Because it was still jointly titled with husband and wife. Instead, he had to obtain a decree of the court in which Judge Atkins stated that the property would be divested out of wife, invested in husband, and as a result, it then went into his estate. So that's the status of this property. So, Your Honor, it is not accurate, as Mr. Shackelford argued, that we are trying to seek payment of our attorney's fees from property that is owned by the estate. That's not what's happening in this case, Your Honor.
Is your lien limited to the assets your former client, the wife, was to receive, or was the lien upon the real estate and/or upon the real estate specifically?
It was upon any assets that the wife was to receive, Your Honor, and specifically, Your Honor, it stated, and she was to receive several other assets in the divorce. And so our notice of attorney lien that we filed in this case, in which was deemed valid and enforceable by order of the court following a hearing on our motion to enforce the lien, stated that the lien is upon all money and all real, personal, and mixed property that has been or will be recovered by Ms. Brady-Brunkhorst, including her car, the Wells Fargo 401k that she was awarded in the divorce, an asset plan that she was awarded in the divorce, her alimony, and her interest in the real property. So, Your Honor, it was, frankly, a very standard notice of attorney lien that we file in domestic relations actions all the time when a client has failed to pay all that they owe. It's not uncommon for the attorney to file a lien in the underlying divorce action. And that's all that happened in this case. Now, very unfortunately and very tragically, of course, Ms. Brunkhorst was responsible for the murder of her husband, Mr. Brunkhorst, and the estate got involved, and that's how we ended up here. But, Your Honor, the underlying facts and the underlying sequence of events is very typical of what happens in all divorce cases when a former client has failed to pay the attorney's fees owed. And that's what happened in this case, Your Honor. And so that's what we're trying to enforce, is that underlying lien, Your Honor.
Ms. Bowers, when you file your motion to enforce the lien, you file that against what party or parties?
We filed that, Your Honor, we gave notice, Your Honor. At that time, there was no estate. And so we, not only did we file our notice of lien and give a copy of said notice to the attorney representing Mr. Brunkhorst in the underlying divorce action, who was the only counsel in effect at that time, we also recorded it in the registrar's office, Your Honor. So that's who we gave notice to. And then, Your Honor, we had a hearing in front of Judge Atkins, and Ms. Angela Snyder, who was the attorney for Mr. Brunkhorst at that time, was present at that hearing. And so his interests were represented. The court granted our motion to perfect and enforce attorney lien, and in the order granting motion to perfect and enforce attorney lien, both myself on behalf of BSHR and Ms. Snyder on behalf of Mr. Brunkhorst signed that order, Your Honor. So I hope that answers Your Honor's question.
Well, let me just be clear. So both the husband and the wife were parties to your motion to enforce the lien?
They were, Your Honor. We gave notice to Ms. Baker-Brunkhorst, who was incarcerated at that time. And we also gave notice to Mr. Brunkhorst through his counsel of record at that time, Ms. Angela Snyder. And both Ms. Baker-Brunkhorst and Ms. Snyder had notice of the hearing date, and Ms. Snyder actually appeared at that hearing. when we had our motion to perfect and enforce attorney lien.
And then after the husband died and he's a party to this motion that you filed, what, if anything, did you do to make a substitution as to the husband?
We did not, Your Honor, do anything to make a substitution as to the husband. Your Honor, it's my position. I believe that it is if a substitution was to be made as to the husband, I believe that the estate, when they chose to intervene and file a motion in this action, since they were wanting to take steps to continue this litigation, that the burden was on them to file a substitution to substitute the estate in for the husband at that time, Your Honor. We were simply seeking to enforce our lien as to our former client.
What was the husband alive when your firm filed the motion to obtain the lien and when the order granting the lien was entered?
It was not, Your Honor, nor had an estate been opened at that time. If there are no further questions, Your Honor, I have completed my argument.
All right, thank you. We'll hear from Mr. Shackelford on rebuttal.
I think the court has zeroed in on a very important issue. The husband was deceased when they filed the motion to enforce the lien. Ms. Bowders, in her brief, has cited to me Rule 25.01 from an appellate standpoint about substitution of parties, and I believe, Judge Armstrong, that rule clearly states that the burden of substitution is on the party that is asserting the underlying claim. In this particular case, the underlying claim was the attorney's lien that was filed 7 days after the husband was murdered. And as Ms. Bowder has just admitted, they never filed a substitution. Therefore, I would argue that the lien that they had filed for that very reason was void from its very beginning. I would also like to correct Ms. Bowders on one thing. Neither property was sold. We were trying to attempt to sell the first property, but because of the attorney's lien, it created a cloud on the title, and there was no way that we could go forward with the contract. It was foreclosed upon, and at the end of the day, there was $10,300 left over that belonged to the owner of the property. That's what's in escrow, and less the attorney fees of Mr. Siegler, which I assume have been a couple of $1,000s. That's what we're here arguing about today. I continue to maintain the position that it's improper for Ms. Bowders and her law firm to attempt to collect attorney fees owed by the wife from the property that was awarded to the husband, invested in the husband, and later vested in the children when he was never ordered to pay those attorney fees. Ms. Bowders has also described to the court substantial assets that Ms. Brady-Brunkhorst received in the divorce. My question to the court is, why are they not going against those assets? Why can't they collect their attorney fees from assets that they argued and received from Ms. Brady-Brunkhorst? Why do they have to go against assets that should rightfully go to the deceased children of Mr. Brunkhorst? Your Honor, unless you have any questions, that's all I've got except to say this. This is just wrong. What they're doing is wrong. It should not be allowed, and I'm asking today for justice from Mr. Brunkhorst and asking for justice.
I do have a question, Mr. Shackelford. How could the husband have been the sole owner of the real estate when the wife had not executed a quitclaim deed?
Title had vested in him, according to the Roberts case, upon the entry of the marital dissolution agreement.
Roberts case appears to be distinguishable, Mr. Shackelford. The Roberts case said the real estate is conveyed upon the entry of the deed. In this case, it says the wife shall execute a quitclaim deed in exchange for payment, and neither had occurred.
Well, she didn't execute. Payment was periodic payments, Your Honor. It was over a period of time. Payments had begun, but they ceased upon his death, obviously. And she failed to execute the quitclaim deed as she was ordered to do within 30 days of the entry of the order. So she had breached the marital dissolution agreement from the very beginning.
All right.
Now, what we have here, Your Honor, I'll just say this. What we've got is we've got a cloud on the title with this attorney's lien, which tied my hands as the personal representative for the estate. I couldn't deal with the property because of this. Ms. Bowders and her law firm had created this cloud on the title in hopes to recover funds that they should have tried to recover from their own client and should not be allowed to recover from the estate of Mr. Brunkhorst and his children. Thank y'all for your time.
Thank you. Unless there are questions from the panel, we thank both counsel and we shall take this case under advisement. Mr. Hibner.
This honorable court is now in recess until 11 a.m.
Thank you, Mr. Hidner. God bless you.
Thank you.
Thank you.